Hello and good morning dear students and welcome to BYJU'S Exam Prep IAS. Let us take a look at the articles we have lined up today for today's Hindu News analysis. So here are the articles. The first article is about the recently finalized amendments regarding the forest bill. So the standing committee of the parliament has said that no changes are required in the bill that was presented in the parliament regarding the amendment to the Forest Act of 1980. So what is it? What are the controversies related to that? We'll take a look at that. The second topic is that in the Namami Ganga project, the role of turtles it is being seen. In Varanasi, turtles are helping clean up the river Ganga. So how are they helping and what is the history of Namami Ganga project? We'll take a look at that. The third topic is regarding the World Trade Organization's dispute resolution system. How USA has been blocking this system. What are the reasons that USA is doing that? The final topic in the main analysis portion is about a report by the Ministry of Education regarding the performance of various districts of India with regards to educational levels. It has been seen that there is a dip in the performance of the various educational institutes, the various schools in the districts because of the pandemic. And finally, in the prelim section, we have two articles. One is about BRICS. Now you know that there is an arrest warrant that has been declared against the president of Russia, that is Vladimir Putin. So in that case, will the BRICS summit will it take place or not? We'll take a look. Finally, you all know that Chandrayaan 3, the third lunar mission of India, it is going to get launched on July 14th. So it will be launched using this vehicle. So what are the details regarding this vehicle? So we'll start with our first topic. Objections overruled, forest bill goes to House unchanged. So all of the objections that were placed on this forest bill that was introduced in the parliament by the government, it then went to a standing committee. And standing committee said that all the amendments that have been proposed, they are good to go. So what is the point of contention? We'll take a look. See, the government, it is set to amend the Forest Act, the Forest Conservation Act of the year 1980. Okay. So in 1980, this major act was introduced in India after 1927 act that was introduced by the British government of India. Now 1980 act, it was aimed at ensuring the prevention of excessive diversion of the forest lands for any kind of non-forest use. So the main intention was conservation, that the forests that we have, they should be conserved, they should not be cut and used for any other non-forest activities. So the forest clearances that were required under this act, they were quite stringent. The current amendment, it is now being blamed for diluting these provisions that were protecting the forest under the 1980 law. So what are the points of contention under this law? The first is that this new amendments, they empower the central government to divert any kind of forested land, be it dense, very dense, sparse, open forest, anything. They can put it to any kind of non-forest use as long as due compensation is provided against that forest use. If it's a private forest, then to the private owner. If it is a government forest, then to the Campa fund. Now this power of the central government, it also extends to the lands that are not classified as states by the center or by the states in their record. Now what might happen is that certain states or the central government, they might declare a parcel of land as a forest land. However, they have not notified this. They have not notified this in their gazette. So if it is not notified, it will not get protection under this new amendments that we are trying to see. Now the bill amends this act. The bill that has been introduced, it is bringing the amendment to cover only a few types of areas as forests. What are these? One, those that have been declared as forests under the Forest Act of 1927. Second category that is included, those that have been declared and notified as forests under the 1980 Act. So basically it will be excluding what all? It will exclude two categories of land from purview of the Act. One, the land that has been recorded as forest, only recorded, not notified as forest before October 25, 1980, when the new forest law of 1980 came into being. And the land which changed from forest use to non-forest use before December 12, 1996. Why is this date important? This date is important because in 1996, the Supreme Court of India, under this case known as Goda Varman case, it extended the protection of the Forest Act to the non-forest regions as well. So any area that was sent to non-forest use from forest use after this date, it is not included before this date, before this judgment and ruling, that is not included anymore under the Protection of Forest Act. Okay. So another thing is that apart from exclusion of a large tracts of land that is forested in principle but not notified as forest land, apart from this exclusion, what are the other points of contention? The construction of various projects like highways, hydel power projects and other projects in geographically sensitive areas that lie within the 100 kilometer of the international border, they will no longer require any kind of forest clearance. Now this is done basically to increase our preparedness in case any of our neighbors, any of our hostile neighbors, they want to attack us. Secondly, to include the villages in the border areas in the developmental story of India. So this is the main intention for this. However, there is a very big issue with regards to this principle. We'll take a look in the upcoming slide. See, the 1980 Act, it had centralized any kind of permissions required for using forested land for non-forest use. So what it had done? It required permission of the central government if any state wanted to divert the forest land to a non-forest use. But now no permission would be required in three cases. First is that if there is creation of any strategic linear projects, the straight projects like roads, like railways, if any linear project, any project of national importance and which concerns the national security, they are created within 100 kilometers from India's border. Now this brings into the question the northeast region of India. Now the northeastern part of India, it is one of the most densely forested region of India, right? Apart from that, it is also a part of biodiversity hotspot. Now this rule that no forest clearance would be required if the region lies within 100 kilometers of the international border. This covers a majority part of many of our northeastern states. Now these states, they are already facing a lot of deforestation because of shifting agriculture, various projects, the environmental degradation, And because of these reasons, they are already experiencing a lot of deforestation, which is affecting the ecology of the region. Moreover, it has been said that, okay, you might plant extra forest through the Campa fund at a different region when the forest in this region it is cut. But what about the biodiversity? What about the animals that were living in that region? What about the climate changes that will happen in the ecology of the region? So these are the points that the northeastern states they have raised against this particular provision. Apart from that, states would also not require any permission from the center if there is a need to create any security related infrastructure up to 10 hectare or defense related projects like camps for paramilitary forces or public utility projects that are specified by the central government within 5 hectares, both of the left-wing extremism affected areas. So again, this will hamper what? The development and the rights of the tribal communities that are living in that region. Okay, so northeastern area of India, it is getting affected. The tribal regions, they are also getting affected because of this act. Now, what is the reason given for this? Why has central government stated that the states would not require any kind of permission? They have said that this causes a lot of delays in the project. Sending the whole project report to the center to get the forest clearances, it causes a lot of delays. However, what about the data we have received from Ministry of Defense? Now, according to this Ministry of Defense data, there are 51 border road projects which are awaiting any kind of clearances regarding the forest. Out of these 51 projects, 29 of these, they are awaiting clearance at the state level and not the central level. So states, they are a part of the problem, they are not a solution. Apart from that there are also other clearances that can delay the project, like wildlife clearances, like land acquisition. So forest clearances, they are not the biggest reason for these delays. Apart from this particular act, it also removes the restriction of the 1980 Act for creating any kind of infrastructure that will aid national security and create livelihood opportunities for the people who are living at the periphery of the forest. So these forests, they could be cut for creation of livelihood opportunities in this region. Okay, so forests can be removed for these communities as well, right? So this is another thing, another point of contention, that the Forest Act, it is getting diluted by these amendments. Now, what is the history of forest laws in India? See, the history, it goes back to the time of the British. Now, please note that the sole aim of the British colonial power was to exploit the resources of India for its own benefit. So, the acts that came into being before independence of India, they were very exploitative in nature and they had more of an economic orientation at the cost of society and at the cost of the environment. In 1856, for the first time, Lord Dalhousie, he realized that there is a need for a forest law so that the various forest areas of India, they can be properly exploited for economic gains. In 1865, the first Indian Forest Act, it came into being and it brought all the forest areas in India under the control of the British colonial power. The Forest Act of 1878, it established the monopoly of the state, of the government, of the British India government over any kind of use of the forest. So the communities who were dependent upon the forest for their day-to-day needs, they could not use these forests unless they had special permission from the government, from the then government. So this use of forest, which earlier was a right of the communities, they did not have to beg in front of anyone to use the forest for their needs. It now became a privilege, that if the government wants, they can provide the privilege to these communities. Okay. Then came the Indian Forest Act of 1927. It aimed again only at facilitating the exploitation of Indian forest. It did not give a fine definition, a proper definition of what is included in the forest, so that the government could declare any region as a forest land and start exploiting and exploring it. It divided the forest region into three categories. One was the reserve forest, where the local communities, even if they were historically living in that region, they were not allowed to enter over here. Next was the protected forest, whose economic potential was completely under the state control. So the state and only the state had the right to explore any kind of economic potential that comes out of the use of timber or any non-timber products like fruits, like raisin and other things that comes from these forests. Then was the village forest. These were certain forests that were given by the government to the communities and the villages for their use. However, the village forests, they were very less in number. Then after independence, what happened? Up until 1980, we were following the 1927 law itself. In 1976, what happened? The 42nd Amendment Act, it came into being. It was passed in the Parliament. Now this Amendment Act, it brought the forests under the concurrent list. This Amendment Act, it is also known for including Article 48A under the DPSPs, right? So 48A, it aimed at protection of the environment, forests and wildlife. So the role of center was seen as equally important as the states in terms of the forest protection. Earlier it was under the state list, now it was brought under the concurrent list, right? Then came the blockbuster act, that is the Forest Conservation Act of 1980. Now the main objective of this Forest Conservation Act was conservation of forest. It wanted to restrict any kind of diversion of the forest to non-forest uses. It wanted to restrict the leasing of the forest to private individuals and entities, and it wanted to prevent clearing of naturally grown trees in any region. Okay. Now, after that came the National Forest Policy of 1988. Now, this forest policy, it introduced the joint forest management. It recognized the role of the communities, the forest dwellers, the traditional forest dwellers, indigenous communities with regards to conservation of forests. So, they, along with the community, along with the forest department, both were given the responsibility for conservation of the forests. Then came the Forest Rights Act of 2006. It was more socially aware act compared to this policy. It recognized the forest dwellers and it gave them the right to ownership of land within the forested region, settlement rights in the forest region if they have been living in those forests for certain amount of years. They also had the right to cultivate and collect the minor forest products, sell them and earn their livelihood. The main intention was to reduce the resentment amongst the forest dwellers regarding the forest policies of India and also conservation of the forest. Now this particular amendment, it is doing what? It is allowing the increased diversion of the forest land for the non-forest use even in the regions that are resided by these forest dwelling communities. Okay. However, please note that this amendment, it does not allow any of these for private individuals. Any kind of diversion that we mentioned in these slides, this diversion is allowed only by the central or the state government or their entities and not by any private individual. Okay, so this is about our first topic. This is the second topic now. The second topic is, in Varanasi, the turtles are helping clean the river Ganga. Now, how are they helping? And what is this scheme? How did it came? How does this idea come into the minds of the people? So since the year 2007, almost 12 out of 29 species of turtles that we have in India. Now there is a difference between turtle and tortoise. The word tortoise includes the word toes, right? So toes are used for what? Walking on the land. So tortoise are the ones that walk on the land. The turtles are the ones that swim under the water. Okay. So this is the difference between turtles and tortoise. We are talking about turtles. So India has 29 species of turtles that are found within the country. Out of that, around 12 species of turtles, they are becoming a very big part of the Namami Gange program. In 2014, this whole story started in the year 2014. When the Wildlife Institute of India, the WII, and the Ministry of Environment, Forest and Climate Change, they collaborated with the National Mission for Clean Ganga, which is the implementation agency of the Namami Gange program. So they collaborated with each other so that since 2017, they have been running what? A turtle breeding and rehabilitation center in Uttar Pradesh, Varanasi. Okay, so it is done in Varanasi. We have this breeding program where the turtles, they are bred and then they are released in the Ganga river. So up until now, since the starting, around 4,000 turtles, they have already been released in the Ganga river, and 1,000 more turtles, they are to be released very soon. Now, how are the turtles helping? See, turtles, they have a role because they feed on meat as well as the waste products that are thrown in the river. So one of the biggest intention of Namami Gange program is what? Reduction of pollution. So this includes reduction of pollution of the organic waste as well, right? So organic waste needs to be reduced. So organic waste can be both herbivore, for herbivores, that is plant-based. It can be carnivore, that is animal-based, right? So both the herbivore and carnivore turtles, they are being introduced in the river to help clear any kind of rotten or half-burnt human or animal bodies and the various flowers that are dumped into the river, especially in Varanasi. See, Ganga is a very holy river. So that is why a lot of worshipping, it keeps on happening at the various ghats of river Ganga. So a lot of flowers are thrown. In Varanasi has very big funeral grounds, so over where a lot of bodies, they are brought from all over the country to get burnt and get the moksha, right? So that is why all these things, they are dumped. They get sometimes dumped in the river. And to eliminate these kind of waste, the turtles, they are being introduced in the river. Now this will help in what? Improvement in biochemical oxygen demand of the river. Now if the biochemical oxygen demand, it increases, that means there will be a degradation of that water body, right? So this particular move, it will improve in the biochemical oxygen demand of the river by reducing the amount of waste in this. Now this waste, when it is acted upon by the aerobic bacteria, these aerobic bacteria, they use oxygen in order to degrade this material. So this increases the biological oxygen demand of the water, right? So this biological oxygen demand of the water, it also needs to be improved. So this move will help in reducing these organic wastes in the water. This will also help in reducing the amount of fecal coliform. Fecal coliform is a bacteria that can cause problems like diarrhea in the human body. Apart from that, it will also improve the dissolved oxygen quantity in the water so that the marine animals, they are able to properly survive under the water. So it has already been seen, a study was done at 20 locations within the river, and the officials found that they have seen improvement in the levels of dissolved oxygen, biological oxygen demand and fecal coliform at 16 out of 16, 14 and 18 locations respectively. 16 locations saw improvement in dissolved oxygen, 14 in BOD and 18 in fecal coliform. However, the experts say that this is a long process, and in identifying the actual result, identifying the actual impact of these species, it will take approximately 10 to 15 years. However, please note that even under the Ganga Action Program, which started in 1985, even under that, the turtles, they were released in the river Ganga, and approximately 40,000 turtles, they had been released in the river Ganga, but no proper studies they had been done regarding the impact of these turtles. There was no timeline regarding when these turtles, they were released in the river. So that is why we do not have proper data to conduct a study of the impact of these 40,000 turtles. Now we are keeping a track of the number of turtles being released. We are keeping a track of the various identifiers, various indicators that determine the quality of water in the river, and that will help us in assessing actually what is the impact of that species. Now a little bit about the Namami Gange program. It is a flagship program. It has been in work since 2014. It is one of the biggest, globally biggest schemes for revival, rejuvenation and conservation of a river. It is centrally funded and it has a corpus of rupees 20,000 crore. The objectives, they are twofold. One is reduction of pollution, and the second is conservation and rejuvenation of the river. Now this particular program, it is operated by the Department of Water Resources, River Development and Ganga Rejuvenation, which comes under the purview of the Ministry of Jal Shakti. It is implemented, however, by the National Mission for Clean Ganga and the State Mission for Clean Ganga. So all the states that are surrounding the Ganga river, they have to establish a State Mission for Clean Ganga, which coordinates with the national mission in implementation of these projects. Now the main pillars of this program include sewage treatment infrastructure to reduce the pollution of mainly the organic and municipal waste in the river. Second is riverfront development. This is the river, you are standing over here, so that means river is in front of you. So riverfront development, it basically means development of the banks of the river. Beautification, increasing livelihood opportunities at the bank locations. Next is river surface cleaning. This is very obvious, cleaning of the surface. Then improving the biodiversity of the river, including the Gangetic dolphins. Next is afforestation, which is also a very important part of this scheme. Afforestation helps in what? Bringing in the ecological balance in the region. Public awareness, because no scheme will be successful unless there is an involvement of the local public. Unless the public, they start to own that scheme and to ensure that no one violates the provisions of the scheme. Industrial effluent monitoring. There are many industries along the river Ganga and its tributaries. So it needs to be ensured that all the effluents that are coming out of the industries, they are properly treated before they are released in the water in order to reduce the pollution. Then Ganga Grams. The Ganga Grams are the various villages that are alongside of the river Ganga. Okay, so these are the various villages along the river Ganga. Development of these villages so that these villages also understand about the scheme and ensure that the river is properly conserved, ensure that there is no pollution. Apart from that, there are certain other initiatives that have been started by the government of India for Ganga river. The first was 1985. Now 1985 was an important year with regards to environment because it was the year when the Department of Environment, which came into being in 1980, it finally became what? The Ministry of Environment and Forests. So this ministry, it started in the same year, the Ganga Action Plan. Now the intention of the Ganga Action Plan was to improve the water quality by ensuring that any kind of domestic waste that enters the river, it is properly treated or it is diverted to treatment plants and then sent to river Ganga. The National River Ganga Basin Authority, it also was started in the year 2009. Now it is the same year where River Ganga was declared the national river of India. So in 2009, this authority, it came into being under the provisions of the Environment Protection Act of 1986. It was later changed, the name was later changed to National Ganga Council in 2016, and the National Mission for Clean Ganga, the implementation agency of the Namami Gange program, it is basically the implementation wing of the National Ganga Council. Then Clean Ganga Fund, it was set up in the year 2015 as a trust. Now within this fund, any individual, any company, they could deposit money which will be used for establishment of the waste treatment plants, conservation of biotic diversity of the river, right? So even the CSR activities of the companies, under the CSR activities, they could deposit funds under the Clean Ganga Fund. In 2017, the National Green Tribunal, it also gave an order for protection of the river Ganga. It banned any kind of waste disposal in the Ganga river. Okay. So this is about the second topic. Now we come to the third topic, a very interesting one regarding the World Trade Organization. So what is happening in World Trade Organization? What is the issue? Why this article has been published? See, the problem is that the United States of America, it has been blocking a very important issue in the WTO. It is blocking the appointment of the members of World Trade Organization's Dispute Settlement Systems Appellate Body. So if there are any disputes amongst any countries like India and say USA, then these disputes which are related to trade, they can be brought to the World Trade Organization. The World Trade Organization will try to sort these issues, right? So USA, however, it is acting as a roadblock in this dispute resolution system of WTO. So because of this, because they are blocking this appointment of members in the appellate body, this is causing the body to be non-functional. So the body has been non-functional since when? Since 2019. Okay, so it has been 4 years already since when the body has been non-functional. Now, why is this very important? Why is this also known, this dispute settlement system also known as the crown jewel of WTO? Because this body, it ensures that even if the country is very small and it is pitted against a very big economically and politically powerful country, then even in that case, there will be a free trial that will be given to both the countries so that this country's interests, they can be protected. The smaller country's interests can also be protected against these big giants. So since WTO's inception back in the year 1995, this body, it has been upholding this international rule of law, especially with regards to trade, so that these powerful countries like United States, like European Union, they are not able to overpower the weaker countries. Now recently what happened in 2022, June 2022, that is 1 year ago, the Geneva Ministerial Conference, it was held. Ministerial Conference, it is the highest decision making body of WTO, and these conferences are held every 2 years. So in 2022, this conference was held where Mexico, it tried to bring a resolution for appointment of these members. This resolution was again blocked by the United States of America. The resolution wanted the resurrection of this appellate body of the dispute settlement system of WTO. However, they were not able to do it because of USA, right? However, the countries, they adopted a resolution that no matter what, they'll try to resurrect this body by the year 2024. Now, why is USA against this? Why is USA against this dispute settlement system of WTO? See, officially, the comments that USA has given, they include that this body, it engages in judicial overreach and exceeds its assigned institutional mandate. USA says that its exact role, its exact purview of working, it has not been defined by the World Trade Organization, and that is why what is happening, that is why this organization, this dispute settlement system, it is breaching its boundaries, it is going beyond in the regions where it should not interfere. Now you will say that USA is the only nation that is opposing this. Then why cannot the rest of the nations, they can pass this resolution? The reason is because the WTO, it works on the idea of consensus. Unless all the members, they agree on a particular point, this particular point, it cannot be taken forward. Okay, so it's, if tomorrow India decides that we do not want this to happen in WTO, then India will have the power to block that thing. It is not like USA has extra powers. Apart from this, USA says that it has been creating this dispute settlement system, it has been creating various binding precedents through its decisions. For example, there was violation of ABC principle of WTO. Okay, now the ABC principle was violated by USA against India. So India filed a case against USA in the dispute settlement system. A particular decision was taken. Now this decision was taken, it was kept in the records. Now in the future, if any other country, for example, country like say Sri Lanka, has the issue regarding the same principle against any other country, say Australia, then this precedent will be followed. That means that this particular principles that were evolved during this discussion, during this decision, the same will follow in this particular issue. So that means they have been creating the dispute settlement system. It has been creating binding precedents through its decisions. Same thing happens with our Supreme Court also, right? Now Supreme Court, it might make a hearing. The best example is the Keshwanand Bharti case. Now Keshwanand Bharti case, it set a precedent. It said that the basic structure of a constitution, it can never be violated. And that precedent, it is used for future cases as well. Same thing is being done by the DSS. They are also following these precedents. Also, this particular argument of USA is also flawed on other issue. That means that DSS has clearly stated under the Article 3.2 of WTO's dispute settlement understanding that in case any extra principles are violated, in case any extra facts they come in the second case, then they will be considered. It is not like the same decision that were taken in the first case, they will be completely imposed upon the second case. Only if they are exactly same in nature, only then this will be imposed. If there are extra facts in the second case, then they will be considered during the dispute settlement. It clearly states that. So this is a flawed argument by USA. The DSS, it asks the WTO panels that are created for the dispute resolution to follow precedents where the issues are exactly same, but it has visibly clarified on many occasions that a departure can be made from previous rulings and reasoning if there are cogent reasons, if there are extra different reasons. Okay? Also, this particular court, this dispute resolution system of WTO is not the only international court of the world that is following its previous decisions. There are many other courts like the International Court of Justice, the International Tribunal for the Law of the Sea, which comes under the UN clause, which have been doing the same. Many national courts, they also do the same. In fact, even the USA courts, they do the same. Then what is the issue? These are not a valid reason to bring in problems with regards to dispute settlement system. The problem is this. So USA, it is stating that it has this problem, that it is going beyond its jurisdiction, it is creating binding precedents. But the real reason that the experts say is this. There is a larger game plan of USA in this regard. They want this de-judicialization of trade multilateralism. They do not want to let go of their sovereign rights of doing trade, of conducting trade in favor of any kind of multilateral agreement. They want to basically take their own decisions. So judicialization, see, judicialization, this is an idea that came into being after the Cold War ended. The world, it wanted to live together in peace and harmony. So many countries, they allowed some of their laws, they forgo some of their sovereignty so that an international agency, it can develop certain laws which will be followed equally by all the countries. However, now, especially since 2010s, this particular intention, it has been reducing. The countries, they want more powers, they want more sovereign rights even on international issues. And this problem is further escalated by the Chinese involvement. See, China, it has been increasing its geopolitical and economic powers. So USA does not want to stay behind. So that is why it wants to break this judicial system of WTO with regards to international trade. Also, another issue is that USA has just been criticizing this system. Up until now, it has never provided any kind of constructive solutions for this issue. So that is another problem with this stance of USA. Now, what is the solution? See, I told you that all the decisions of the World Trade Organization, they are taken by the consensus. All the members, they should agree to a particular issue, and only then WTO can move forward. However, some experts say that in this case, because this has been pending since 4 years now, in this case, instead of following the consensus path, they should follow the voting path. Okay, so they should vote, and whichever solution gets the more votes, they will be applied. However, there is an issue that this will antagonize the USA, and USA is one country which is controlling the international currency, which is one of the biggest geopolitical powers, and so no one wants to antagonize that. Also, US is the only country right now that can stand against China. So these are the problems why resorting to voting might not even be a solution. Now, what is the dispute resolution procedure at WTO, which I talked about up until now? See, WTO has a ministerial conference or ministerial council, which is the highest decision making body, and it takes the decisions based on consensus every 2 years. Every 2 years there is the conference. They also have a general council for the day-to-day activities. Now, this general council, it itself meets as the dispute settlement body whenever any kind of decision regarding the disputes is required. Now, DSB, this dispute settlement authority, has the sole responsibility or the sole right and authority to establish panels of experts to consider any case. Example, this is India versus USA. So a panel, at the first stage, a panel will be created for this dispute resolution and discussion. Then it also has the authority to accept or reject any findings of the panel or any results of an appeal. Now, if the countries, they do not agree to the decision of this panel, they can appeal it to the appellate board. Now, any reports by this panel or by the appellate board, they can be accepted or rejected only by the DSB. It also monitors that the rulings that are given by the dispute settlement bodies, they are properly implemented. Also, it authorizes any kind of retaliation in case one of the parties or more parties, they are not agreed, they do not comply to any of the decisions of dispute resolution. Now, what is the appellate body, which is requiring the election of members? Appellate body is a 7-member body which is appointed by DSB every 4 years. In every 4 years. So, even 2019 to 2023, this should have been a duration for one of the appellate bodies. But since then, we have not been holding any kinds of elections. So, these are appointed by the DSB or the General Council basically. Because the General Council is the DSB, okay, for a duration of 4 years. Now, these members, they should be persons who have an expertise in law, international trade, and subject matter related to the World Trade Organization agreements. So this is the entire procedure. Now India filed a complaint against USA. So India is the complainant, USA is the defender, right? So complaint is filed. First a consultation is held. If the consultation it is fruitful, then a mutually agreed solution it can be put into place. If no settlement is achieved, then a panel is established by the DSB, Dispute Settlement Body. Now if this panel is able to find a mutually agreed solution, then it can be implemented. If no settlement at that stage also, then a report is submitted by this panel to the DSB. Now this report, now on the basis of this report, an appeal is filed. Now if in this case the defendant wins or there is no appeal, then there is a settlement. If the complainant wins, then there is implementation. If no one wins and there is an appeal, then an appellate review is being done by the appellate body. Now this appellate body, it does this review. In this case, if the complainant wins, then there is implementation of that decision. Otherwise, there is settlement if the defendant wins. Now, if there is no proper compliance of the decisions given by the dispute resolution bodies, then a compliance panel procedure is followed. If the complainant it accepts that it is not following those procedures, following those principles, then there can be a settlement. Otherwise, a compliance panel procedure starts, where if the complainant wins, then there is compensation or suspension of any kind of concessions given by either the WTO or any country, the complainant to the defender. If the defender is found to be compliant with that particular issue, then there is settlement. Okay, so this is the entire procedure of how dispute resolution takes place at the WTO. Now we come to our last topic, which is about a very important report released by the Ministry of Education. Now this report, also known as the Performance Grading Index for districts. Now the district level report, it was released yesterday on July 9, and the state level report, it was released on July 8th. First, let us take a look at what are the findings of the district level report. Then we'll go to the state level report as well. So Ministry of Education has released it. So if a question in your prelims comes, which particular agency releases this report, Performance Grading Index, then you'll know. Now, this time a combined report for 2020-21 and 21-22, it has been released for the districts. Now this report, it assesses the performance of school education, okay? So when we are talking about performance, it is only school performance. We are not talking about any kind of higher educational institutes. So school educational performance at the district level. Now this particular report, it categorizes the various districts of the country into 10 categories, depending upon the percentage of marks that they have received on the various indicators that are included in this report. The best grade that can be received by this first grade is Daksh, if the score is more than 90%. Then we have Utkarsh, Ati Uttam, Uttam, Prashesht 1, Prashesht 2, Prashesht 3, then Akankshi 1, Akankshi 2, and the worst, that is Akankshi 3. So there are 10 categories or 10 grades on which every district it can be graded. So what are the findings? none of the districts across the country, they earned the top 2 grades, that is the Daksh and the Utkarsh, for both the reports, both 2021 as well as 21-22. In 2021, 121 districts, they received the Ati Uttam grade, that is the 3rd best grade. However, there were only 51 districts who achieved the same grade in 2021-22. So between 2020-21 to this year, there was a reduction in the performance of the districts. Okay, so the report says that this is the impact of the pandemic. It is the impact of the pandemic which brought down the performance of these schools on all the indicators. Many districts, they fell in their rankings and settled at the lower grades. You see over here, this is the data regarding both the reports. We are matching both the reports. You can see how there was more than 50% decline in terms of, sorry, this is 124, okay, in terms of decline in number of districts from the 3rd grade. You can see even here how the number of districts, they fell down to this category from above 2 categories. So there was a fall seen in the performance of the districts because of the pandemic institute issues related to funding, related to availability of digital infrastructure, availability of teachers as well as students, and many other reasons. So this shows that pandemic had a very bad impact on school education at all the district level. There is one district, only one district which came in the Akankshi 1 category, the lowest category, because the categories below that, it did not have any districts. It was the South Salmara Mankachar district of the state of Assam. Now, how will this be helpful for the states? Now, this report, it has a lot of indicators on which marks are given to all the districts. So, if the state departments, state education departments, they can see what are their marks in the various indicators, they'll be able to find out the exact problem areas, and they can ensure that they make policies to address those exact problem areas. You know that education is what? A state subject. So when the central government, it is releasing any kind of information about a subject that belongs to the state government, then we can say that it is kind of a neutral party. So this is basically a kind of a third party evaluation of the educational systems of the various governments. So state governments, their departments can identify the various gaps at district level, at such micro level, and improve their performance in a very decentralized manner. Now there are 600 points which are distributed across 83 indicators that are identified over here. These indicators, they are categorized into 6 categories. Now what are these 6 categories? Please take a look with utmost attention. First is outcomes. Second is effective classroom transactions, infrastructure facilities and student entitlements, school safety and child protection, digital learning, and the governance process. Now these categories, these 6 categories, they are further divided into 12 domains that include learning outcomes and the quality. Whether the students are able to learn all the things that are given to them in the classrooms. Access outcomes, whether the students are able to access all the material that is provided by the teachers or the school. teacher availability and professional developmental outcomes. Whether proper teachers for all the subjects are available, if they are getting any kind of trainings, is that improving their development, their professional development, learning management, learning enrichment activities, like activities like tours, various tours to various locations, various activities within the classes, the projects, and so on. Infrastructure includes infrastructure for disabled, libraries, digital infrastructure, laboratories, facilities, various facilities for the students, student entitlement, school safety and child protection, whether they have proper guards, whether the buses they are proper or not, digital learning opportunities to the students, fund convergence and utilization, if the funds they are getting, how are they being utilized, attendance monitoring system both for the students as well as for the teachers, and school leadership development. Now the states, they also, for states as well, on 8th it was also released. For states it was first released in 2017 and 18. The recent report that was released on 8th July, according to that, none of the states or union territories, they achieved the top 5 grades. Chandigarh and Punjab, they were the top performers which achieved the Prashesht 2 grade. So top 5, none of them. The poorest performing states which belong to the Akankshi 3 category, the last category, includes Arunachal Pradesh, Meghalaya and Mizoram. Now quickly we will cover the prelim bites. The first topic is about BRICS. Now the International Criminal Court, it has released a warrant against Vladimir Putin that if he steps in any country that is a member of ICC, then that country will have to arrest Putin. Okay. Now South Africa, it is a member of ICC, and the next BRICS summit, it will be held in South Africa next month. So the Prime Minister of South Africa has said that it will be an in-person meeting. But how will Putin come here? No one knows. So latest summit, it has to be held in South Africa. The term BRIC, Brazil, Russia, India, China, it was first coined by a British economist. None of these countries were involved in the coining. It was coined by British economist Jim O'Neill in 2001 to show the emerging economies of the world. The grouping, it formalized in the year 2006 as BRIC. In 2010, the word S was introduced. It became BRICS. The first summit was held in June 2009 at a place known as Yekaterinburg in Russia. In the latest summit, the 14th summit that was held in Beijing, an important outcome of that summit was the Beijing Declaration, which was focused very much on the Russia-Ukraine war. So it said that BRICS supports talks between Russia and Ukraine. It also advanced, all the countries, they advanced support to the United Nations as well as the International Committee of Red Cross, which is monitoring and delivering the humanitarian aid to the country of Ukraine. This declaration also showed its concern regarding the presence of Taliban in the country of Afghanistan and how that is causing a lot of human rights violations. The next topic is a very interesting one, which is about the LVM-3. Now the Chandrayaan-3 mission, which will be launched on July 14th, it will be launched using the LVM, Launch Vehicle Mark 3. Now ISRO has 3 types of launch vehicles: the PSLV, Polar Satellite Launch Vehicle, GSLV, Geosynchronous Launch Vehicle, and the newly created Small Satellite Launch Vehicle for the very small satellites. Now PSLV is one of the most successful launch vehicle of ISRO, and it has been launched for the most number of times. It has a very low failure rate. That's why many countries across the world, they prefer ISRO's PSLV for sending their satellites for space. It can launch up to a weight of 3.8 tons in the low Earth orbit. Then GSLV, it is used for the higher orbits and for heavier payloads. The LVM-3, it is the most powerful GSLV that we have. So what are the features of LVM? See, it is a 3-stage launch vehicle. In the first stage, it uses a solid fuel. This fuel is called hydroxyl terminated polybutadiene. In the second stage, it uses a liquid fuel. So that means first stage is a solid stage, second stage is a liquid stage. It is using liquid fuel and an engine, an indigenously created engine known as Vikas engine. So the fuel used over here is either nitrogen tetroxide or unsymmetrical dimethyl hydrazine. The third stage is a very important stage, and this is the stage because of which our GSLV took so much time to develop. That is the cryogenic stage. Cryogenic means extremely cold stage. So this is the uppermost or the final stage of this vehicle. It is powered by a cryogenic engine. The fuel that is used over here is liquefied hydrogen with liquefied oxygen as an oxidizer, right? So that is why, because we need liquid gases, that is why the temperature needs to be very less, and that is why we need cryogenic conditions in this stage. So this is the end of this session. First, we discussed what? The forest amendments that are being brought in the parliament of the country. Second topic, we talked about how turtles, they are useful for the Namami Gange project. Third, we talked about the dispute settlement system of World Trade Organization. And finally, in the analysis portion, we talked about the report by the Ministry of Education on performance of the district schools as well as the state level. In the prelims bites, first we talked about BRICS, and the second topic was about the LVM, which will be LVM-3, which will be used to launch Chandrayaan-3. Here are the mains practice questions. The first question is, forest laws of India have evolved from being economy centric to the environment and society centric over time. Elaborate. You can mention how before independence they were mainly economy based, only for exploitation of the various resources. Later on, conservation of forests became a very important part of 1980 Act. In 1988, the policy it started introducing joint forest management, as well as in 2006 Forest Rights Act was introduced. Okay, so you can elaborate easily on this aspect. You can also in the conclusion mention that how the recent amendments, they might have certain concerns regarding dilution of the environmental and the social aspects of the forest law. Second is, what is the dispute resolution system of WTO? Why is it under threat recently? Now DRS we have very extensively discussed in this session, right? You can easily write about it, how there are panels. The decision of the panels can be appealed in the appellate board, right? Why is it under threat recently? Because of the actions of USA, because of which since 2019 we have not been able to appoint any members of this appellate board. So this is all about today's session. I hope you were able to understand all the parts of it. So thank you very much and have a very good day ahead.